Appears to contradict the Trump administration's mortgage fraud allegations against Fed Governor Lisa Cook. NBC News looked over Cook's bank records this past week and found no evidence of corruption. President Trump attempted to remove her from her position this summer, but so far, she is refusing to leave. Well, joining me now, we have former federal prosecutor Barrett Berger. Welcome, Barrett. So President Trump, as you know, tried to fire Lisa Cook. That happened back in August. It is the first time a president has attempted to fire a top Fed official. Where did this case come from, and where do you expect it to go from here?
So the case is really concerning whether the president has the power to fire her under the Federal Reserve Act. Now, this act says that governors can only be removed for cause. So the whole question swirling in this case is, what does that mean, and was there cause in this case? So we know that the administration has pointed to alleged mortgage fraud that they claim that Cook committed, not while she was in office, but years ago. And they've pointed to that and said this now gives them the authority to fire her because we have this cause or this alleged criminal activity. So the question for the court now is, can you consider acts that were done before somebody was in office? And even if you can, what kind of due process would Cook deserve? How much does a court get to weigh in on whether these allegations actually would support a finding of cause in the first place?
Can I ask you if it's true, as NBC News has reported, looking over these documents that they show that she identified this home as a second home, a vacation home. She did not seek a lower mortgage rate. She did not seek exemptions, again, according to NBC News reporting. If that gets presented to a judge, does the whole case get thrown out the window?
Yeah, I mean, in order to actually prove mortgage fraud, prosecutors would have to show that she was really intentionally trying to mislead the lender about what she intended to do with the property. So while, again, I don't know that we can definitively say that these documents show that she was fully transparent.
Right. Maybe there
or
are
made the right
others.
disclosures.
We don't know. Right.
Correct. But if they are accurate, and if this, does show that she at least intended to be somewhat transparent about how she wanted to use this property as a vacation home or as a second home, then certainly that would make it almost impossible for prosecutors to put forth some sort of a mortgage fraud case. So to the extent we're looking at whether this now gives the president the authority under the Federal Reserve Act to fire her for cause, I would think that would be much more difficult to make that case in court now.
So just this year alone, the Trump administration has filed about the same number of applications for emergency rulings as the Biden administration did over 4 years. We're talking about 8 months or so compared to 4 years. Overwhelmingly, the Supreme Court has ruled in the Trump administration's favor. So put that into context for us, Barrett. Is, first of all, this a typical number of emergency filings? I mean, did the Biden administration underfile? Or I'm curious about the rulings and what they say about the court.
Yes, so we have seen a huge influx in the number of these, emergency petitions or things that would go to what's called the shadow docket of the Supreme Court. These numbers have increased pretty dramatically since around the late 2010s. And we see courts issuing more frequent decisions on really consequential issues on this sort of shadow docket. What we've seen now in the last administration here is an even bigger increase of those. So what do we read into that? First of all, we read in frustration on the part of the American people because these shadow docket decisions, while obviously completely appropriate, lack the transparency and ability for the public to really know what the Supreme Court was considering and who was responsible for them.
They give their ruling, but they don't have to offer any reasons why.
Correct. They don't have to offer reasons why. They don't have to say who was the one authoring, who agreed with this. In some of the recent ones, we have known who was dissenting, but we don't know who was the person authoring them necessarily or the reasons why. Again, remember, there's no hearing if something's on the shadow docket, as there would be in a case that was proceeding in the regular course. So we don't get to know from the judge's questions and oral argument how they're thinking about this. So it is a very frustrating way to deal with consequential legal issues because it's dealt with so little transparency. Why are we seeing so many of these? Well, I think we're seeing a lot more action on the part of the Trump administration that's causing the Supreme Court to have to rule in quickly. We're seeing, whether it's the use of executive orders in such an increased way or decisions by district courts staying policies of the administration. So more is getting up to the Supreme Court. So that may be one reason why we've seen an increase. But we do know that it's, whatever increase we had seen since 2010, we've seen this jump even more so with this Trump administration.
Okay, Garrett Parker, good to see you as always. See you again soon. Thank you.